Well, good morning to everyone. Welcome to the International Arbitration in Latin America, the State of Play, organized by the CAM-CCBC in partnership with Colombia International Arbitration Association. My name is Patricia Kobayashi, and I'm the CAM-CCBC Secretary General. On behalf of CAM-CCBC, I would like to thank Gustavo and the Colombia International Arbitration Association for reaching out and for suggesting such an incredible event. I would also like to thank all the panelists for their contribution and for the institutional support. I thank Canal Arbitragem on our arbitration channel, an institution also focused on expanding and improving ADR's best practices. Finally, I thank all the students, researchers, and practitioners that are watching us. I hope you can enjoy the event and take as much as possible of the knowledge that will be shared. But before we start, I will take this opportunity to briefly share some of CAM-CCBC's numbers and most recent experiences. The fact that the pandemic imposed many obstacles on pretty much every aspect of our lives is no longer news, and hopefully, we seem to be reaching its final stages. That is why the CAM-CCBC will soon publish the CAM-CCBC 2020-2021 Facts and Figures, a publication of data from this very unique time. Contrary to what would be expected, after the outbreak of the pandemic, the number of proceedings initiated at CAM-CCBC registered an increase, 8% in 2020 and 23% in 2021. Last year, CAM-CCBC received a total of 128 arbitration proceedings, the second highest number of cases initiated in a single year since CAM-CCBC's foundation in 1979. If we exclude Brazilian parties, which represent the majority of the parties involved in the cases administered by CAM-CCBC, we will see that in 2020, 14% were parties from other Latin American countries. In 2021, that number reached 18%. In 2020, our ongoing cases were fully transferred to our newly minted case management platform. After that, we adapted our structure to hold all the hearings remotely and improved our cybersecurity protocols. I should mention that CAM-CCBC provides for full administrative support to the cases, aiding counsels and arbitrators in every stage of the proceedings. Well, the 100% online case management also substantially reduced the use of printed materials, contributing to a greener arbitration. Just to illustrate, we're talking about over 20,000 letters, approximately 720,000 Brazilian reais, which would amount to 130,000 US dollars, just in courier expenses. Just imagine the amount of paper. But the changes were not restricted to the technical aspect of the conduction of the proceedings. In 2021, CAM-CCBC launched its expedited arbitration rules, providing for an even more efficient arbitration for cases not amounting to more than 3 million Brazilian reais in disputes. Another major advance was the draft of the updated version of the CAM-CCBC arbitration rules, which was submitted to public consultation last year. Today, we are at the final stages for the approval of the new CAM-CCBC arbitration rules. But enough from CAM-CCBC. Today, and on March 25th, the following Friday, we will be discussing the state of play of international arbitration in Latin America. For that, we will hear the unique perspectives of top-notch practitioners from the US, Brazil, Argentina, Chile, Uruguay, Peru, Colombia, and Mexico. The international arbitration community will certainly benefit from key information on political, economic, social, and legal scenarios of several Latin American countries to better understand how they approach the arbitral process and how the judiciary cooperates or not with arbitration. Getting to know how things work for arbitration in Latin America is our goal today and next Friday. There will be, of course, no time to exhaust each and every interesting topic, but we hope to give you a good taste of what arbitration is like in Latin America. So, without further ado, I wish you all an outstanding webinar. Thank you. And I pass to Gustavo.
Hi, everyone. Good morning. Thank you, Patricia, for the kind introduction. On behalf of the Columbia International Arbitration Association, I would like to thank CAM-CCBC in your name, Patricia, and in the name of its president, Eleonora Coelho. Also, a huge thanks to Andreas and Ana Flavia for working so hard to make this event happen. We really appreciate your work. And it's a pleasure and an honor, of course, for us Columbia Law School students to be part of this joint effort between CAM-CCBC and the Columbia International Arbitration Association, mainly to discuss such an important topic, right, which is the state of play of international arbitration in Latin America. I don't want to be too long here, but in this first panel, we will address the US view of Latin America, as Patricia mentioned. And by the US view, I just want to be clear here that we mean how US practitioners see Latin American jurisdictions and when it comes to international arbitration. And this is important. Why? Because as the audience might know, US law firms usually work very close to Latin American jurisdictions. They have a lot of Latin American lawyers, so it's really an important topic to get acquainted to. So before we kick off, I would like to introduce the two speakers we have here today. I will introduce them very quickly. Both are very experienced and have a lot of practical experience in international arbitration, and they have a very extensive resume. So to make two long stories short, I will introduce you now to Ari. Ari is a partner in the New York office of Clear & Gottlieb, and his practice focuses on international arbitration matters with a particular emphasis on Latin America and corruption issues. And I would like to introduce you also to Michelle. She is a member of the International Arbitration Group of White & Case. She's based in DC and specializes in international and cross-border disputes with a particular focus on Brazil and also in Latin America. So without further delay, let's hear what our speakers have to say about some interesting questions. Here it goes. The first one to warm up. Ari, I would like to address the first one to you. So here it goes. Do you see Latin American countries in general as important players in the international arbitration scenario, be it commercial or investment trade arbitration?
Thanks for the question, Gustavo, and thank you everybody for having me here together with Michelle. This is a great event, and I really appreciate the invitation. So, as far as whether Latin America is an important jurisdiction for international arbitration, I think the answer is, and I believe Michelle would agree, 100%. It's an extremely important jurisdiction, and it's not just because Michelle and I do much of our work in Latin America. I think objectively speaking, if you look at some of the numbers that institutions put out, Latin American parties comprise a very important percentage of the parties that are involved in international arbitration. So if you look at the ICC statistics that they put out for 2020, 16% of parties are Latin American parties. I think the numbers obviously for CAM-CCBC would be much, much higher. But even for an institution like the ICC that's got its base in Paris, you have 16% of parties coming from Latin America. And that's the second highest in terms of any region. It's just Europe that has a larger percentage of parties in ICC arbitrations. Brazil is number one among the Latin American countries in those statistics. Not a surprise because of how large the Brazilian market is, but I think it's also a sign of how arbitration is on the incline, is increasing in Brazil as well. And it's an important market, Latin America, both from the perspective of commercial arbitration and treaty arbitration. On the commercial front, a lot of concession agreements in key jurisdictions relating to key infrastructure, oil and gas, mining projects provide for arbitration of disputes. That's fairly typical in a number of jurisdictions. There's also a lot of cross-border M&A work in Latin America involving investors either from other Latin American countries. There are a number of large multilatinas that do investments across Latin America, or from the US and Europe, as well as from Asia. And for those cross-border M&A transactions, we often see arbitration as the dispute resolution mechanism of choice. There are also, certain jurisdictions in Latin America where arbitration is viewed in an extremely positive light. I do a lot of work in Peru, for example, and I know there'll be a panel on Peru in particular. That's a jurisdiction where arbitration has found its way into the Peruvian constitution as a mechanism of dispute resolution. And you see it playing an extremely important role as the mechanism of dispute resolution of choice, really, for significant disputes. And obviously on the treaty front, there have been, and I think will continue to be, a number of important treaty arbitrations in the LATAM region. There are a number of sovereigns in Latin America that, for better or for worse, sort of top the charts among the sovereigns who are most sued in treaty arbitrations. That includes Argentina, Venezuela, but we see a lot of arbitrations these days in Peru, in Colombia. There have been a few against the Chilean state as well. Mexico has the specific aspect of being part of NAFTA, or the new North American treaty replacing NAFTA, where you've got a lot of NAFTA arbitrations. And, as all of us know, there is a fair amount of political, social kind of instability in some regions of Latin America, which tends to generate treaty arbitration. So, to answer your question in short, I think Latin America is an extremely important market for U.S. practitioners. In my experience, it is the number one most important international arbitration market outside of the United States itself. And I think it will continue to be an extremely important market, both on the commercial side and on the treaty side. Thank you, Gustavo.
Awesome, Ari. Very interesting. Michelle, would you have any comments on this question?
Sure. But first of all, I also wanted to thank you and CAM-CCBC and the Columbia International Arbitration Society for the invitation. It's a real pleasure to be part of the event today. So I agree with Ari, as I couldn't agree. Latin America is very important, and it does have a key role in arbitration in the commercial side as well as investor state side. And I would add to the data that Ari added before, the new statistics from the ICC for 2021 that just came out also have Brazil again as the second most highest ranking parties in ICC arbitrations. And interestingly, Mexico is now the 5th, which last year it was the 10th and has moved to 5th. So you have 2 Latin American countries among the top 5 countries in ICC arbitration. So that is and ICC has a huge number of arbitrations. So that in itself already shows the importance of Latin America. And in the investor state side, the story is very similar. ICSID releases its statistics for 2021, and the statistics also show that about 28% of the ICSID cases, from historical cases coming from the beginning of the existence of ICSID up until today, have involved Latin American countries. So the numbers are very significant. And another data point that I think is interesting comes from the White and Case and Queen Mary University survey. The 2021 version also has 2 seats from Latin America, and as part of the top 10 seats in the top 20 seats, top 20 worldwide. Sao Paulo is one of the top 20 worldwide, and Sao Paulo and Lima are between the top 10 for the region of practitioners, not the region of Latin America, but practitioners who work with Latin America. So those numbers are also significant. And I think we cannot ignore also the importance of that the arbitral institutions from the region are gaining. Like CAM-CCBC is present in most of the key arbitration events, including the Vismut, which is a worldwide event. And other institutions are such as like the Chambers of Commerce of Santiago, Bogota, and Lima are also household names now for people that work in the region. And based on my own practice, which for the past 10 years is about 90% focused on Latin America, I can say that I have seen a number of arbitration clauses with seats in Latin America and administered by institutions that are regional institutions, such as the ones that I just mentioned. And when reviewing clauses, sometimes for my colleagues that are doing transactions, sometimes they say, you can review the clause, but we have heard that the institution and the seat are non-negotiable. So please provide us some background on this institution. We want to know the institution a bit, but we have the sense that we're not going to be able to do much about trying to change to another institution. So I think those data points make it clear that Latin America is gaining more and more importance in the field of arbitration.
Awesome, Michelle. Thanks for that. Now I would like to start the second question with you. So do you feel that the judiciary in Latin American countries is pro-arbitration? I mean, is the judiciary seen as a safe port to guarantee the legitimacy and efficiency of the arbitral proceedings? We can think here two scenarios about, for example, anti-arbitration injunctions and the enforcement proceedings. So what are your thoughts on this issue?
So Latin America is a region full of disparities, including as regards court support for arbitration. So there are countries that have fairly equipped and well-functioning judiciaries, and others in which that is not the case. So that, to start with, will have some reflection on the role of the judiciary in arbitration. In the first group of the countries, the ones that have fairly well-equipped and well-functioning judiciaries, I would say that the answer to the question of whether the judiciary is a safe port to guarantee the legitimacy of arbitration is yes, more and more so. And I'll start with Brazil. In this group of the yes, more and more so, you'll find Brazil. And Brazil is an interesting case study because until about 20 years ago, there was no or little arbitration in Brazil. And in 2001, the Supreme Court confirmed the constitutionality of the Arbitration Act. And since then, arbitration has really flourished. And the success of arbitration in Brazil is in great part due to the support of the judiciary. And key to that support was providing training to the judges. In this regard, like the Brazilian Committee of Arbitration, CBAR, played an important role together with institutions like CAM-CCBC. Without that process of educating the judiciary, maybe the results would not have been so good as we see today. But today, the result is that Brazil's judiciary is largely pro-arbitration, in particular in the big cities that tend to be more common seats of arbitration, such as São Paulo and Rio. Last year, there were some statistics came out that indicated that about 19% of the awards challenged in the Brazilian courts in the past 5 years were annulled. And some people were very surprised with the number and thought that it was quite high and started to wonder if Brazilian courts were losing their passion for arbitration. And I think that it's difficult to draw any conclusions from this statistic without looking at what drove those annulments. And the study that was published didn't get to that point. I think in a large country such as Brazil, not all arbitrations are administered by reputable and experienced institutions and arbitrators, as is the case with CAM-CCBC. In Brazil, there is numerous institutions in many parts of the country. So not all of them have the same quality. So if there are real problems with certain awards and with the process through which they were issued, then I think that the courts are actually doing a favor for arbitration to annul the awards. And I don't think it's something problematic. Now, moving to another country, Argentina. Argentina is a country in transition, I would say. In 2004, its Supreme Court issued a decision in what is known the Cartelone case, in which the Supreme Court allowed courts to review the substance of arbitral awards that when there were allegations that the award was unconstitutional, illegal, or unreasonable. And this decision raised eyebrows in Argentina and just about everywhere else because it allowed full-on review of arbitral awards. In a 2018, a few years later, in a 2018 study on arbitration in the Americas by the University of Leicester, it's interesting that Argentinian respondents expressed a very negative view of their arbitration laws and the attitude of the courts. And notably, like the majority of the Argentinian respondents did not list Argentina as a suitable place for arbitration. But the good news, I would say, is that later that year, in 2018, Argentina adopted a new arbitration law based on the Antitrust model law. And this law, although it only applies to international commercial arbitration, the international part, the local arbitrations is still guided by the civil code of Argentina. Although all of those, the law, I think, has set Argentina on the right path. And also, it's interesting that now the Supreme Court, since 2016, has an arbitration-friendly justice, Carlos Fernando Rosenkranz, which seems also to be helping Argentina to stay on the right path to a more judicial, more arbitration-friendly judiciary. So there's still time to come and see what's going to happen in Argentina, but I think there is a positive trend going on. Now looking at the other end of the spectrum, we find countries such as Bolivia. And the Bolivian judiciary has the problem that I mentioned before, that it's less equipped, less well-trained. And in fact, organizations such as International Commission of Jurists have called the Bolivian judiciary as unprepared, inefficient, and lacking independence. And the lack of independence is really a concern for international arbitration, in particular, arbitrations involving state entities or companies. Because in such cases, there is a significant risk that any award will be annulled by the state courts, or that during the arbitration, you will face intervention by the courts against the party that is against the government. So I think that's like a general overview of what is going on in Latin America, as we will hear about other countries in the coming days. And I think Peru, Mexico will also provide good stories of how arbitration is growing and the judiciary supporting arbitration more and more.
Thank you, Michelle, for the thorough analysis. The statistics you mentioned, really, they were very criticized here by the Brazilian community. So, Ari, do you want to add anything here on this topic?
Yeah, just very briefly, I completely agree with Michelle that the analysis depends on the jurisdiction in question. There are a number of jurisdictions that have excellent reputations for having pro-arbitration judiciaries. We field questions from clients frequently who ask, we want to pick a neutral site or for our arbitration. We don't want it to be the country of our opponent, but nor should it be our country. But we also don't want to be in New York. We don't want to be in London or Paris because it's just way too expensive and it's too far away. Is there a jurisdiction in Latin America that is going to assume that role of being the seat of choice, like an independent seat of choice? And we frequently give, recommendations. Santiago, Chile comes up frequently. Montevideo comes up. Both of those locations are sometimes a bit far away, but those two jurisdictions, Chile and Uruguay, have extremely good case law, pro-arbitration case law that's very consistent. In terms of where you have risks, like Michelle, I've had very good experiences with Sao Paulo seated arbitrations and the view that the Sao Paulo courts will take of arbitration. I have the same experience for the most part in Mexico City, but sometimes when you get into some of the other cities outside of the centers of commerce or the centers of finance and arbitration, you can run into some risks. So even in states or countries that tend to have pro-arbitration jurisprudence, I've had issues in Chihuahua in Mexico with anti-suit injunctions. I've also had issues, as Michelle mentioned, in Bolivia with annulments of arbitration awards. I think one of the areas, as Michelle mentioned, that you have to be particularly sensitive to when you're picking a seat or deciding on whether a particular jurisdiction is a good place to seat your arbitration is the question Michelle mentioned of are the state's interests implicated? And if so, how? And be very careful about that, because that's an area where even if you have a pro-arbitration friendly jurisdiction, I think of Lima, for example, as a place where I've done a bunch of arbitrations. You do have some concern that depending on the what's going on in the country at that point in time, that the judiciary might take a different view toward your arbitrations. Maybe that concern is not legitimate or substantiated, but the concern does arise. And I will tell you that for a lot of the important concession agreements in Peru, for example, when the arbitration has an amount in controversy above a certain threshold, the parties are often given the option to change the seat from Lima to another country outside of Peru, or to another seat outside of Peru. And I suspect that the reason for the existence of that clause is essentially what Michelle and I are mentioning here, that when the state's interests are implicated, there's at least a perception or of a concern, potential concern in certain jurisdictions. So maybe I'll leave it there.
Thank you, Ari. So since we have just 30 minutes and you have mentioned what I would ask in question 3 about the political atmosphere, and you well said that sometimes when states' interests are involved, things can change. Maybe we could go to the last question here. Yeah, so Ari, I would ask you to start this one, please. So Brazil is one of the few countries in Latin America that has not signed the Washington Convention, therefore does not take part in investment treaty arbitration under the ICSID Convention, right? So do you think Brazil could benefit from being a signatory to this convention? And how important is it for a country to be part of the investment arbitration mechanism? I'm just talking about Brazil here because maybe Brazil is kind of the only one in Latin America that hasn't signed the convention, so it's worth directing this country. Thank you.
Yeah, absolutely. And I'll be brief because I know we're short on time. My impression is for Brazil in particular, I do not have the sense that Brazil is suffering significantly because it is not a signatory of the Washington Convention. My view is that there are a number of reasons for that. Brazil is an enormous market, as we all know. It's an incredibly important market, increasingly so. And it's, to my mind, it's difficult for a lot of international companies to ignore the Brazilian market, regardless of whether Brazil is a signatory of the Washington Convention and there's the possibility of bringing a treaty arbitration. So my personal view is that Brazil is not being significantly affected by the non-signing of the Washington Convention. I think there have been studies to that effect that have tried to measure the flow of foreign direct investment and have not seen that it makes a huge deal of difference or bit of difference in the case of Brazil. What I would say is there are other large countries like Mexico, for example, that just signed the ICSID Convention a couple of years ago. And my view of Mexico was somewhat similar, that although they've now signed, that it's such an important market, such a large market, and still it's only half the size of Brazil, that it can get along perfectly well without being a signatory of the convention. Are there benefits at the margins? Perhaps. Where I think it makes the biggest difference for countries is those small or medium-sized countries where perhaps there isn't the same need for companies to invest or perceived need for them to be in those countries, and maybe there isn't as large a market. And there, I will tell you that when our clients are thinking about investing in a particular jurisdiction, treaty protection has become increasingly important. It's not as important as tax issues, but it rivals tax issues when you're talking to clients about how they want to structure their investments, through which country are those investments going to be made. So companies are thinking about it, but I don't think in the case of Brazil is suffering as a result of not signing the Washington Convention. I'd be curious to hear Michelle's view on that as well.
Well, yeah, Michelle, the floor is yours. Thanks, Ari.
Yes, no, so I agree with Ari that Brazil's approach here has been to rely on the size of its market rather than try to attract investors by offering legal guarantees. Though, like, I do have, as he said, like he has his anecdote about clients asking about tax and investment treaties. I also have an anecdote in that respect. Once I spoke with the head of a business promotion bureau of a major European country in Brazil, and he explained to me that one of the first things that investors that are considering to invest in Brazil ask are, one, is there a tax treaty? Second, is there an investment protection treaty? So it is possible, Brazil does attract a lot of investment, but it's possible that it would be attracting even more if it had those treaties in place. And I think we also need to think about Brazil's outbound investment. because the current approach does not protect Brazilian companies that are investing outside Brazil, and that number of companies of Brazilian multinationals has increased. And so far, a lot of Brazilian companies have been able to benefit from investment treaties from other countries through a smart structuring of their investments in a country. But we've been seeing that more and more treaties are changing and in requiring a more substantive link by the investor with the home state. So it is possible that in the near future, sometime in the future, the Brazilian companies will no longer qualify to take advantage of this treaties between other countries by just establishing a subsidiary or an office somewhere to qualify for that protection. So that's another aspect, I think, that needs to be taken into account, the protecting Brazil's investors abroad. Then I would say that one other positive thing for Brazil is that even though it has been reluctant at providing direct access to arbitration through international treaties, it has accepted arbitration as a means of dispute resolution in contracts between states, between the state and state entities and investors. So for that, if you have a contract, if you are an investor that you are dealing directly with the government and you have a contract with the government, then it's very likely that you'll get arbitration to resolve your dispute, if in particular, if your concern is being in Brazilian courts. The only thing is that if you do not have established relationship with the government in a measure that the government adopts affects you, then you're not protected by anything else. And as a foreign investor, the only solution is for you to go to a court in Brazil. And some foreign investors are not super excited about going to a court, complain about a measure of the government in which that court represents, them being a foreigner. So some food for thought for Brazil. We know that Brazil has tried to make an effort, has signed some cooperation agreements, which are more focused on avoiding disputes than actually resolving them. So if Brazil is successful at avoiding the disputes, then we might not have a need for anything that requires arbitration.
Thank you, Michelle. Thank you, Ari. I would love to spend much more time here, but unfortunately our time is over. So thank you, Ari. Thank you, Michelle. Thank you, CAM-CCBC and Arbitration Channel as well. And now I would like to pass the floor to my friend, Eduardo, who will take care of the Mexico panel. Thanks so much.
Thank you, everybody.
Thank you. Bye-bye.
Thank you, Michelle. Ciao, ciao. Bye.
Thank you very much, Gustavo. And well, first of all, thank you to CAM-CCBC and the Colombia International Arbitration Association for organizing and for inviting us. And in this panel, we're going to talk about some of the current issues we have in Mexico with arbitration. And for that, we have two guests that really need no introduction, but I will introduce them nonetheless. So first of all, we have with us Cecilia Azar, who is a lawyer in arbitration, mediation, and judicial procedures. She has more than 25 years of experience, and she joined Galicia as a partner in 2018, where she focuses on complex domestic and international commercial disputes. She acts as arbitrator, counsel, mediator, and expert. She serves as one of the ICC International Court of Arbitration. She's the vice president of the Arbitration Commission of ICC Mexico, and she was appointed as conciliator for Mexico in the exit proceedings. In 2021, she was included in the Chamber's list of most in-demand arbitrators for Mexico, and she's the first woman to ever be included in that list. We also have with us Eduardo Siqueiros. He's a recently retired partner from Hogan Lovells in Mexico City, where he practiced for 40 years in commercial, joint ventures, investment, insurance, and infrastructure law. He received his law degree from Escuela Libre de Derecho in Mexico City, and he also holds an LLM degree from Harvard Law School. He has been a professor of several law schools in Mexico. He actively participates as arbitrator in domestic and international commercial disputes in several institutions, and also in investor-state disputes before ICSID and before the PCA. And he's currently a governing board member of the International Council for Commercial Arbitration. So thank you for being with us, Cecilia and Eduardo. And if you agree, we'll just get right on it. So Cecilia, I would like to start with you. Ari just mentioned that in the previous panel, that he's had some issues with anti-suit injunctions or anti-arbitration injunctions in certain part of Mexico, and they have become an increasingly common practice in Mexico. Could you maybe explain the mechanics of these court orders and how Mexican courts, tribunals, parties have reacted to them?
Sure, Eduardo, thank you very much. I'm very happy to be here. I'm going to be very brief because we don't have a lot of time, and we have a list of interesting topics for the following half an hour. So about precautionary measures, those are instruments used by the state and arbitral courts during the course of a litigation or an arbitration by which it is seek to protect the subject matter of the dispute and to facilitate compliance with enforcement of the final judgment or an arbitral award. So this is very important. The precautionary measures are seek to protect the subject matter of the dispute and facilitate compliance with enforcement. That idea, I mean, that first idea is very important to take into account. So Mexican law provides for concurrent jurisdiction between state courts and arbitral tribunals in connection with the issuance of precautionary measures. That means that during an arbitration, we can ask the state courts or the arbitral tribunal to provide for these measures. Mexican commercial arbitration law adopted the UNCITRAL model law in 1993, and there's no provision that expressly provides which precautionary measures can be issued by the state courts. I mean, there's no limit in terms of the type of measures that can be granted. Article 1425 of the Commerce Code establishes that even if there's an arbitration agreement, the parties may, prior to the arbitration agreement proceedings or during the arbitration proceedings, request the judge to adopt interim measures of protection. And Article 1478 provides that the judge shall have full discretion in the adoption of the interim measures. This full discretion has opened the door for state courts to be in possibility of issuing anti-arbitration measures, or at least that full discretion has been wrongly interpreted as having the possibility to issue anti-arbitration injunction. So what's an anti-arbitration injunction? It is an order that seeks to restrain a party or the arbitral tribunal from commencing or continuing the arbitration proceedings. These remedies are highly controversial, of course, because their legal existence itself is very, very much in dispute. This injunction can be seen as threats to the authority of arbitral tribunal and even to the principle of competence. So we're talking about a measure that, again, restrains the arbitral tribunal or a party to continuing the arbitration or commencing the arbitration itself. So this is very controversial, of course, and we have seen several criteria going on in the Mexican courts in this regard. The Mexican courts have stated that the substantial purpose of the precautionary measure consists of anticipating the possible execution of an eventual favorable ruling for the plaintiff, and avoiding irreparable damages or damages difficult to repair that could be caused by the necessary delay of the proceedings. So the granting and exercise of the discretional powers of the state courts to issue these measures doesn't go to the extreme of giving carte blanche to the legal operator to subjectively decide whatever he wants. So such powers must be subject to standards of rationality and coherence in accordance with the prevailing system of sources, the main rule of logic, experience, and proportionality through the discourse of justification presented under the same parameters. So this is, again, very controversial, and I think we are going to keep seeing some type of anti-arbitration measures in Mexico at some point.
Thank you very much, Cecilia. Eduardo, I don't know if you have any additional remarks on that particular point.
Well, it is. I think that just as this was being addressed earlier, major urban centers in Mexico have more trained judges and members of the judiciary. The issue, the critical issue, is in less internationally developed centers, smaller towns in Mexico, which have a judiciary which are sometimes taken by surprise by some litigants and request some of these stays that the judges, simply because of their lack of knowledge, lack of experience, do or may be able to grant them. But fortunately, the trend is decreasing as it is being seen by the judiciary in general, that these measures should not be granted when there is an express agreement by the parties to arbitrate.
You are muted, Eduardo. I think Eduardo has, he has a problem with the mic, but probably, Eduardo, we could move on with the next topic.
Yes, I know that one of the topics that Eduardo wanted to discuss, as he had indicated to me previously, was suits against arbitrators for either claiming that they were responsible for issuing an award that has been annulled, and a claim of their fees. This is if an arbitrator participates in an arbitration in which the award has been annulled by a local court, whether the parties or the party seeking the annulment of that award has a right to recover the legal fees and arbitration costs incurred by that party. And unfortunately, this has been more frequent in Mexico that any arbitrator would like. It started many years ago when the first awards were being issued, and in some complex commercial cases involving substantial amounts of money, arbitrators were being, claims were being brought against the arbitrators at the time that the award was being sought to be annulled. And this placed a heavy burden on arbitrators. It placed a heavy burden on me and many arbitrators, such that even if your fees for acting as an arbitrator had been reasonable at the time of a claim for annulment, the amount of money that you would have to expend defending that claim was even more substantial than the amount you had been paid as an arbitrator. And further, the claim was that you should reimburse not only the parties' costs of arbitration, but also the legal fees they had incurred during the proceeding. So this was obviously absurd. It came to a point where even criminal claims were being brought against arbitrators for acting as such. I and many others in Mexico started joking and saying that unless you had been criminally accused more than once and you had been sued for reimbursement of fees and legal expenses, unless you had been through that, you could not claim to be a well-known arbitrator in Mexico. That was absurd. So what has happened and what is the current, the most current standing and legal precedents in Mexico is that federal circuit courts have now identified that this practice not only is not applicable, but also this is it cannot have standing, and also that the arbitrators are not and should not have legal standing to defend a claim of annulment. So therefore, an arbitrator cannot be sued in case of an annulment action is brought for the award, number one, because they don't have standing, because they are neutrals who participate in a case where they are merely deciding the case. They have no interest in the claim or in the defense. And secondly, as regards the obligation to reimburse fees or even be responsible for the legal fees of the parties, federal courts have also ruled very clearly that the arbitrators have an obligation of means and not of results. This is that their responsibility is to act diligently based on their knowledge and experience to resolve the case, but they have no legal interest in the case itself.
Thank you very much, and I'm sorry for that little technical complication, but I'm back. I'm sorry for that noise.
No problem, Eduardo. I can add a very short comment to Eduardo's presentation, which was very clear, and probably the key issue here is to determine what kind of relationship there's between the parties and the arbitrator, the nature of the arbitrator duty in terms of its service, of the arbitral tribunal service, and this is a professional service contract between the arbitrator and the parties, and unless there is no issue or liability for the arbitrator in terms of its duty, there's no reason to include the arbitrator in the annulment claim of an award. So I think there's a misunderstanding of that type of discussion, that the nature of the arbitrator's activity or service in the arbitration, and having some clarity in that regard would prevent from the parties from keep on including the arbitrator in the annulment of an award.
And
Sure,
don't
and
worry,
that's-
Eduardo, arbitrators and moderators, presenters share the same feeling. Unless you've had technical issues when you're presenting or moderating, you cannot pride yourself to have experience on that position.
That is true, but I think it's all figured out by now. So those recent criteria on decisions on the standing of arbitrator are a good development in Mexico. And another one, and I would like to turn to you now, Cecilia, is about the authentication of awards. So recently there have been contradictory decisions by courts in Mexico about what does duly authenticated award means for the purposes of enforcement. And I don't know if you could maybe explain to us what the courts have meant and what has been the recent decision that finally solved this debate.
Sure, Eduardo, and we have to take into consideration that Mexico is a very formal country in terms of the interpretation of law. So every time we find a specific requirement for an act for a legal act in the law, it provides for an interesting discussion on the extent of that requirement, and that is the case for the authentication of arbitration awards. So as we know, Article 4 of the New York Convention provides that to obtain the recognition and enforcement of an award, the party applying for it needs to supply the duly authenticated original award or a duly certified copy. So the Uncitron model law adopted the duly authentication requirement of Article 4 of the New York Convention, and the Mexican commercial arbitration law also adopted that criteria. So we can find that requirement in Article 1461 of the Commerce Code, of the Mexican Commerce Code, that says the party that invokes an award or requests its enforcement must submit the original duly authenticated award or a certified copy. So the courts need to interpret what is the meaning of that requirement, the duly authenticated award. What does that mean exactly? So the authentication of a document, we can understand that as a formality under which it is guaranteed that the signature it contains is genuine. It's a genuine or a real signature. The authentication of an arbitration award provides certainty to the state court that the arbitrators indeed signed that award. It reduces the probability of an eventual false allegation of the document by the respondent in the process of recognition and enforcement of an award. So in September 2018, the 14th Collegiate Circuit Court of Mexico City established that the duly authentication requirement implied that the interest party should ratify the signature with a public notary or a public broker, a corredor público, to provide certainty. But then there's another case that was decided by the first chamber of the Supreme Court, and stating that the duly authentication requirement provided for in Article 1461 of the Commerce Code is unconstitutional and contrary to the Article 17 of the Mexican Constitution. That requirement is unnecessary. That was the decision of the Supreme Court. It's an unnecessary formalism. It's a requirement that must be understood as a mechanism to provide greater certainty as to the authenticity of the arbitration award, to reduce the probability of a possible falsity allegation by the respondent. So the lack of authentication does not imply falsity or presumption of falsity of the award, and an arbitration award is a private document that enjoys of a presumption of validity, which binds the party that were subject to the arbitration to comply with the arbitration award. So the only causes that allow confronting the formal and material validity of the award are those expressly stated in Article 1457 of the Commerce Code, which is the article that regulates the annulment of an award. So that's where we are now, but it has been an interesting discussion within the Mexican courts, this requirement.
Thank you very much, Cecilia. Eduardo, I don't know if you have any additional comments on that regard.
Surely. The only thing I would add is that this is another example of how creative lawyers can be. We have extraordinary lawyers in Mexico, just as there are extraordinary lawyers outside, and some of them are extremely creative. Naturally, creativity does not have a thin line of where to decide what you do is ethical and what you do is wrong, but you do this nonetheless to favor your client. Mexican courts, as I had commented earlier, have had some missteps, but and sometimes, as is regarded in Mexico, they perform a dance, 2 steps forward and then 1 step back. Fortunately, after we have one of these steps back, courts and higher courts and Supreme Court or federal courts decide in favor of what is and should be proper interpretation of the law.
Thank you very much. And a last point I want to touch with you, and I start with you, Eduardo, is Canada, Mexico, and the US have negotiated the USMCA to replace NAFTA. Could you maybe explain to us which are the claims that you still can bring as legacy claims under NAFTA? What is the deadline for doing that, and when is the USMCA going to be in full force?
Surely, the USMCA, or TEMEC, as we call it in Mexico, is replacing NAFTA, has replaced NAFTA or in substantive issues. And as many people who followed NAFTA were aware, NAFTA was I should say, a moment where investment and protection treaties really took hold. After NAFTA, these multiplied. Not that NAFTA was the first one, but it was a clear indication that the protection of investment was going into a new chapter. As we know, ex-President Trump decided that NAFTA was what he called the worst trade agreement ever executed by the United States, and negotiations went through to replace NAFTA. NAFTA survived as a USMCA now, but the investment protection chapter was indeed modified. And this may clearly provoke that new treaties or newly negotiated treaties to replace those existing also are modified. How and why were these changes made? First, let's go to the substantive. First, I would simply point out that many protections have been eliminated. The position of states has been increased in this new treaty, and the protection of investors has been removed. Point number one. Point number two, the proceedings to enforce the rights of the investors have changed. And thirdly, the areas of protection, or there have been areas of investment which have been protected more than others. Let me go first to your question. What is happening to those claims that could have been brought under NAFTA? Are they still available? And the answer is yes. The treaty, USMCA, was executed in 2018 and became effective in 2020. It became effective on July 1, 2020, and it has a 3-year window from which any claim that for actions or violations, treaty violations that had occurred during the period in which NAFTA was enforced, this is through July 1, 2020, can be brought. So legacy claims, as these are known, can be brought by any investor of the United States, Canada, or Mexico against the states in which they had invested for the 3-year period ending July 1, 2023. It looks like still a long way away, or it looked as 3 years was a long time when the USMCA came into force, but now we have barely over a year. This means that if an investor needs to bring a claim for actions taken before NAFTA ceased, they will have to begin those. And as we know, treaty claims are not an easy issue, so they will have to move ahead strongly. Canada, as those that might not be aware, is not did not agree to have any claims, investment claims brought under the protection mechanism of USMCA. So this deals only claims between United States and Mexican investors against the other state.
Thank you very much. And a final question I want to ask you, since we're almost without time, and this time I want to start with you, Cecilia, is with these legacy claims that Eduardo just explained, and maybe some other issues that are happening in Mexico, how do you see the investor state environment? Do you feel like there will be more claims coming soon, or maybe not?
I see the environment complicated, Eduardo. Unfortunately, interesting times in Mexico. As you know, the energy sector is the star of the movie right now. There's also some interesting recent decision on mining from the Supreme Court that could also result in some investment claims. So yes, we have been probably not waiting for the Mexican wave of investment arbitration to come, but at some point we think that it's going to happen. We are going to start seeing an increase of this type of claims, because of course the current administration represents an important change in terms of expectations for investors in Mexico, in comparison with the expectation that were generated in the previous administration. So there's a change of rules in the game, and that will, of course, result in claims and investment claims. We'll see. As Eduardo was saying, those are complicated cases, long cost generate. So it's a difficult decision for the investors, and it comes that it's also like the last resource before leaving the country. So I think some of our clients are still waiting to see if there's a light at the end of the tunnel, and see if there's a way to stay in the country and see if there's a way to negotiate some part of their investment. So we'll see. Complicated and also exciting times in Mexico, Eduardo.
Thank you very much, Cecilia. Eduardo, I don't know if you have any final remarks.
Surely, I think I would only add to what Cecilia was indicating earlier. Investors don't like to litigate. We see countless cases being brought against states all over the world. But any lawyer who represents those investors will tell you an investor earns more by doing business, by carrying out its objectives as an entrepreneur, as a businessman, businesswoman, than bringing claims. But there are instances in which states leave no other option. I think the current administration in Mexico is leaving no other option to many investors, especially there is a electrical reform that is being a bill that was submitted to Congress and has been delayed because of the large opposition that this has provoked. But we have an administration that is very stubborn, extremely stubborn, and they will attempt to bring something to Congress. And if this is approved, and if this does affect the rights of many investors who have legitimately invested in Mexico, there's no doubt in my mind that countless claims will be brought against Mexico, not only for the mining sector, as Ceci was indicating, electrical sector, and legacy claims, yes, but depends on which type of claim. Investors in certain sectors, including energy, will continue to be protected, whereas those outside of petroleum, energy, telecommunications, transportation, infrastructure will continue to be protected in the future. Those that are not in those sectors will no longer be protected for these claims.
Well, thank you very much both for all your insights and for your time. We're unfortunately out of time, but I thank you for sharing with us. And with that, I just now I give the floor to Tomas Frenck for the next panel.
Thank you.
Thank you.
Hello, everyone. I think that I can't active my video. It says, okay. Yeah, right now. Well, thank you everyone for being here, and thank you the CCBC and Columbia International Arbitration Association for organizing the event and also for the invitation. To discuss the state of play of international arbitration in Chile, it's inevitable to speak about what is happening in Chile regarding the new constitution that it has been discussing right now. Although we don't have the final draft yet, the deadline for meeting the final draft expires on July this year. The Constitutional Assembly has already approved significant constitutional provisions that would impact the future of international arbitration in Chile, both commercial and investment, and our speakers will surely address later on. So without saying that, I would like to introduce our speakers. First of all, I have the honor to present Nicole Duclos. She is one of the ambassadors that Chilean arbitration practitioners have in the US. Nicole is a partner in the international arbitration practice of Covington and Barling in New York. She focuses her practice on international, commercial, and investment arbitration, as well as transnational litigation with emphasis in Latin America. Nicole has acted as advocate and advisor in dozens of ad hoc and institutional international arbitrations conducted in numerous jurisdictions. Nicole is highly ranked by international and Latin America legal publication in international arbitration and sits regularly as arbitrator. Our second guest and speaker is Cristian Conejero. He is also one of the most prominent representatives of international arbitration in Chile. Cristian is partner from Cuadrecasas in Chile. He advises leading companies on domestic and international arbitration, both commercial and investment. He is acknowledged in Chile and Latin America as a leading arbitration lawyer. He also worked at several international law firms and served as a consul for Latin America, Spain, and Portugal in the ICC International Court of Arbitration, and also he is a professor of the law school in Pontificia Universidad Católica. Well, thank you very much, Cristian, Nicole, for being with us. And well, the first question for you, Nicole. Nicole, well, you are Chilean, you know pretty well the reality in Chile and what is happening right now, but also you have been living in the US for many years and practice arbitration here. So you can provide your perspective of what is happening in Chile right now, and also you can provide your assessment of the situation and what are the challenges that international arbitration has in Chile. Thank you.
Thank you, Tomas, and thank you for the organizers. I'm delighted to be here and to share this panel with you, Tomas, and with Cristian. Look, briefly, I'll address maybe the overview and then give Cristian the opportunity to address some of the challenges as he sees them from the ground. But generally, when we speak about international arbitration and in Latin America in particular, I think we look at it from different angles. And overall, I think we face significant political, social, economic and regulatory transformations in the region. And we've heard some of our colleagues speak in the context of this conference. We look at Mexico. I was just listening to Cecilia and Eduardo, Argentina, Peru, Chile, and depending on how things unfold in Colombia, we may also see changes there. And you could see some resource nationalism, resources, particularly mining and energy, regionalism, indigenization to some extent, and efforts to undertake wealth redistribution through taxation. And in Chile in particular, we see obviously important changes. We just saw a new government take over on March 11th. And it comes with a new political, economic, and legal agenda. In addition, I'd like to emphasize, only because this is quite recent, climate change is an important item in that agenda now. It's not, I think it precedes the current government. Only 2 days ago, Chile adopted, or is about to promulgate rather, but Congress approved the first law in Latin America and in any developing country, at least to my knowledge, that imposes mandatory carbon neutrality, which is quite unprecedented. We have a few years to go by 2050, but it's mandatory, and it imposes the implementation of the NDCs and mitigation plans and monitoring. So that I think will also have an impact on how investments and business is done in Chile. You outlined an important fact, obviously the constitutional process. We have a constitutional assembly that is tasked with coming up with a new constitution. And the process is this is happening as we speak, obviously, and the proposal of new provisions either originated within these committees that compose the assembly, as well as popular proposals, will end in a matter of a few weeks by late April. And these provisions, of course, need approval by the plenary, 2/3, over 100 people out of 154. And then just a few weeks to harmonize the text. And this is obviously needs to be approved by a referendum. But it's happening as we speak, and as you very well said, some provisions have been approved by the plenary, whereas others are just being proposed and will be the subject of voting as a matter of general principle, but also specifically each one of the provisions that are being proposed. So if one looks at what's going on from the outside, and then I'll invite obviously Cristian to go deeper from his perspective. One sees some principles underlying these proposals. I think the protective nature in climate change mitigation, multiculturalism, multinationalism, and pluralism from a judicial legal perspective, which is unprecedented in Chile and very new. Efforts for regionalism or emphasize regionalism, and as I mentioned earlier, resource nationalism. Now, there's a lot going on, a lot of commentary about what's going on, but only a few provisions have already passed, and I'd like to emphasize maybe 3 points that may be relevant as far as our discussion about arbitration is concerned. First, that the state is now going to be broken down in regional and indigenous units, namely municipalities and indigenous territories, which means they'll have independence, legal independence, administrative, and even financial And then we'll also have autonomous regions. The legal system will also experience significant changes. We'll have the national justice system or courts of law as we know them today, but also legal systems and adjudicative bodies for the indigenous people that the indigenous people may appoint. And that's certainly a very significant change. And I'll invite Cristian to address specifically changes that have already been approved as far as arbitration is concerned. Now, there are proposals that have been discussed, but that have not yet been approved by the plenary. But I'll mention a handful of them simply because to the extent they are approved, are very likely to have very significant impact on foreign investment and the resolution of disputes that may arise out of those investments. And those are the potential nationalization of mining resources, which are deemed strategic assets of the state, and the impact of that on mining concessions for exploration and exploitation of those resources, and as well as potential nationalization of companies that undertake both exploration and exploitation of those strategic assets. And I think finally, there is proposals not yet approved to limit the state's ability to agree to international arbitration of disputes that arise out of investments. The only carve out are human rights treaties, but at least the proposal provides for the exclusive jurisdiction of Chilean courts to resolve investment disputes, including those arising out of investment contracts, and also the proposal to withdraw from the ICSID convention. We'll have to monitor how these proposals unfold, but that's sort of a general overview. And with that, Cristian, I don't know if you want to add to that summary.
Very much, Nicole, and thank you, Tomas, for the introduction. I also would like to convey my thanks to the Colombia International Arbitration Association and CAM-CCBC for the invitation. Very happy to join this panel with Nicole and Tomas, both are esteemed colleagues and good friends. I think that Nicole depicted in a very clear way and yet succinctly the overview or the current state of play regarding the constitutional process that it's underway in Chile. I think we shouldn't underestimate what might be the impact. This is not one of those situations when you just say much ado about anything, about nothing. You know that there are some real concerns, and there are already some amendments that have been approved by the Constitutional Commission, which will most likely have an impact in arbitration. But at the same time, I wouldn't voice in an exaggerated way, concerns that so far are not real. And I take the point mentioned by Nicole that there are a number of amendments that have been proposed provisionally by the specific work commissions within the constitutional process, but that haven't been approved yet. And therefore, it remains to be seen what will happen. I'm still hopeful that there will be not a drastic change of the rules that will apply to the different industries that Nicole has mentioned, but it's likely, of course, that some change will be incorporated. However, I'm taking the point that Nicole mentioned regarding the things that have already been approved. It is true that as part of the constitutional process, it has been approved a regime of legal pluralism, where basically we'll have two different systems of law for indigenous people and for non-indigenous people, or the rest of the nation, if you could say so. And it remains to be seen what will be the breadth and the scope of that differences between each regime, to what extent they will share some, like rules applicable to both systems, and to what extent the rules will be drastically different, and in what type of matters. Of course, the broader are the differences, the greater will be the chance to probably have some impact in the context of arbitrations, even in commercial arbitrations. And I would just provide two examples that come to my mind that could potentially be affected by this sort of legal pluralism, that also come hand in hand with, as Nicole also mentioned it, the creation of different adjudication systems for each legal system. So it's not only that they will have each their own laws, but also their own adjudicatory bodies or courts that will resolve the disputes that may arise in the application of those laws. And the first problem that, or potential challenge that one might encounter, is what will be of course, when it comes to problems of jurisdiction, how they will be decided, who will decide them. So far, there is a provision that says that the law will determine the way that conflicts of jurisdiction will be resolved or determined. But of course, we know that in our international arbitration law, there is the universally embodied principle in arbitration of competence, where any jurisdiction objection is not only submitted before the arbitral tribunal, but also decided by the arbitrators. To the extent that this might somehow clash against the jurisdiction of a different body that, for example, for a specific type of dispute that not recognize arbitration, it remains to be seen how that conflict of jurisdiction will be decided, who will decide it, and what could be the potential outcome. The second challenge that I see ahead is one that pertains to the application of the law, and specifically the notions of public order and arbitrability. To the extent that there is a difference in the laws that will apply to indigenous people and non-indigenous people, if there are some provisions specific to the situation of indigenous people that, for example, are more restrictive with respect to arbitrability, or provide for a broader notion of public order, again, when it comes to exequaturs or annulment, it could potentially be a source of problem if that gives rise to different notions of arbitrability of public order. I'm still confident that even if that were the case, and assuming that at least the exequatur will still be retained solely by the Chilean Supreme Court, it should continue to apply a notion of international public order that therefore goes beyond particularities or parochial views of different legal systems that could potentially apply in Chile, to embrace a notion that is more aligned with basic notions of fairness and systems of justice. And if that were the case, of course, the risk of a conflict or conflicting views about public order could diminish. But as you can tell from all this discussion, these are purely hypothetical. We don't know what will really be the scope of this legal pluralism that has been embraced so far by the constitutional process. And again, we'll have to see how all this comes into play.
Thank you, Nicole and Cristian, for your insights. Nicole, I would like to ask you, you talked about before some of proposal or provision that have already approved by the Assembly. So my question is that what are the challenges in investment arbitration for Chile? Later on in another panel, it was said that Brazil can live without exit. That's apply for Chile as well. What is your thoughts about it?
Thank you, Tomas. I don't know if it's just me. I had some slight trouble hearing you, but I did hear the last part. And look, these are proposals, as Cristian noted, but they've been quite vigorously advocated for. Now, this is not the first time we see some of these proposals being advocated in Latin America. We saw it with Venezuela and Bolivia and Ecuador, that is now back as a signatory of the ICSID convention. So generally speaking, I think we need to make a distinction between the proposal that Chile either revise or terminate bilateral investment treaties on the one hand, and on the other hand, the mandate, at least as currently drafted, that it would draw from the ICSID convention. Chile has over 40 bilateral investment treaties in force and over 20 treaties with investment provisions and FTAs. And even if those were to be terminated, as some advocate, they have sunset or survival clauses, which basically means that those clauses are meant to guarantee that the provisions of those treaties will remain in effect for a number of years. So even if that were to be done, it basically means that those treaties and the protections contained therein won't cease to exist abruptly in the case of termination. Now, as far as the ICSID convention is concerned, I mean, Chile has been a signatory since the early 90s. And so far, there's been very few cases registered against Chile, only 6, and frankly, only 1 ruling adverse to the state. Some have been dismissed either on jurisdictional or merits grounds, and 2 are pending. That said, there's been notices, trigger letters served on the state in connection with certain, changes that have unfolded over the last year or so. So it is likely that they'll increase. But that's a track record, and one seems to forget as well that this is a two-way road. It's not just the state potentially being sued under these instruments, but certainly Chilean investors have resorted to bilateral investment treaties and the ICSID convention to assert their rights. And there's even more cases that have been commenced by Chilean investors against foreign states, and at least in 2 that I'm aware of, they've been compensated. So that we shouldn't lose sight of that. Now, if Chile were to notify, the depository of the convention that is denouncing it, there's 6 months for it to take effect, and it wouldn't abruptly end an investor's ability to commence an arbitration claim under the ICSID framework. Certainly not for those who've asserted claims before the denunciation takes place. And then there's obviously, this is not devoid of different. There are different views about the timeframes, of course, but if particularly after denunciation takes place, specifically whether an investor can still resort to the ICSID framework during the 6-month notice period after denunciation is notified, and some tribunals have upheld jurisdiction, particularly vis-a-vis Venezuela. So there's precedents there that one can examine. But there've also been tribunals that have maintained that if claimant consents after denunciation, even during the 6-month period, that consent would be outside of the scope of Article 72 of the convention. And then we have the period after the 6-month notice period, where there's also differing views as to whether claims can be brought. But all that said, the ICSID rules and the ICSID framework is one forum, and if one looks at the Chilean bilateral investment treaties, they provide for UNCITRAL rules, which means that even if an investor were to be unable to resort to the ICSID framework, it would still be able to bring a claim under these treaties, under the UNCITRAL rules, for example. I mean, fortunately, there's a lot written about it, about these, what happens with denunciation. We've had 3 of our neighboring countries do that before, and there's enough precedent that, and like I remember in 2007 when this first happened, people were scrambling to figure out how this would operate in practice. That's no longer the case. I don't know if that addresses the question, but that's sort of a quick summary of it.
Thank you very much, Nicole. And Cristian, I would like to ask you about commercial arbitration, and also I would like to ask you about the role of CAM-Santiago in Chile. Later on, in another panel, it was said as well that Chile, it was a country in Latin America that parties tend to choose because of the neutrality and because it's a pro-arbitration country. I would like to ask you about your insights and particularly in the role of CAM-Santiago in commercial arbitration.
Thank you very much, Tomas. Well, I think that addressing your first question, I think that there we have good news. It's always good to conclude our panel with our hopes high. And I think that if you look at the last judgments issued by Chilean courts in commercial arbitrations, they are very good. They are very supportive of arbitration. Sometimes they go too far in trying to support arbitration, in my view, or sometimes, which is part of the learning curve, they come up with a good decision, but not necessarily with a proper reasoning. So they are approaching, I think, arbitration in a proper way, but they still have, some space and some room to learn. But if you look at the last decisions issued over the last couple of years, they are all very supportive and arbitration friendly. When it comes to annulment, there are no decisions from the appeals court in Chile setting aside awards, and those decisions that have rejected actions to annul or vacatur have basically reasoned that the annulment should not be used as a recourse to revisit the merits of the decision and review the way the law has been established by the arbitrators, or the facts have been properly valued and considered on the basis of the evidence rendered by the parties. So they apply the grounds set out in Article 34 of the arbitration law, which resemble the UNCITRAL model law grounds, in a very restrictive way. Interestingly, in exequatur, they follow the same approach, this time by the Supreme Court. It's a centralized process only before the Supreme Court. There are 2 decisions that came to light within the last couple of years, which are interesting. One is the decision rendered in an international arbitration case, where the parties have basically agreed in the arbitration clause that appeal could be used against the arbitral award in addition to the annulment recourse. And when the award was rendered, the losing party sought to appeal against the award. The Santiago Court of Appeals declared the appeal inadmissible on the grounds that the Chilean arbitration law provided that the annulment recourse was the only recourse against the arbitral award. And I think that reasoning is right, is correct. But the party appealed against that decision. The case went up to the Supreme Court, and the Supreme Court ultimately decided that the appeal was admissible on the grounds that arbitration is rooted in the principle of party autonomy. And if the parties had agreed from the outset in the arbitration clause that appeal was a proper recourse against the arbitral award, then the court should uphold that agreement made by the parties in light of the respect to the principle of party autonomy. This, of course, is in stark contrast with the way other courts have decided the same issue. The Ninth Circuit Court of Appeals, in a case some years ago, in the Lapine case against Kyocera Corporation, was placed in exactly the same position. A party has used an appeal that the parties had agreed and incorporated in the arbitration clause, but there the Ninth Circuit reasoned that it was not up to the parties to put an extra burden on the system of justice provided by the national courts that goes beyond what the law provides for when it comes to the recourses against arbitral awards, and therefore decided that the appeal was inadmissible and that the parties could only avail themselves to the recourses provided under the law. They could not ask from the national courts more than it has been given according to the law. And I personally, and this is of course a personal view, have a lot of sympathy to that principle, especially considering that the arbitration law provides that the annulment recourse is the sole recourse. There is a clearly, I would say, policy behind, which is to avoid that there is further litigation as to the merits of the case before national courts once the award has been rendered. And I see a risk in allowing the parties to jump that principle by agreeing on appeals in the arbitration clause. But of course, this is one judgment, that there is no a string number of cases that support this proposition. So we'll see what will happen when a similar situation comes to the Supreme Court again. Another interesting case, and I know that time is running, so I will be brief. It's an exequatur where an award was rendered under the Swiss rules of arbitration. Disputes arose under a guarantee given to support obligations of supply under a principal agreement, a supply agreement. The guarantee was provided by the parent company, a Chilean company, in favor of the party that acquired those raw materials that were to be supplied by another Chilean company, and the purchaser in this case was a Swiss company, Swiss incorporated entity, and the Swiss entity obtained an award and sought to enforce it against the guarantor in Chile. The guarantor basically complained that it had already asserted jurisdictional objections before the Swiss arbitration that were dismissed, were rejected on the basis that the sales agreement provided for ICC arbitration and not Swiss rules arbitration. And the Supreme Court, in a very clear manner, decided that the award was rendered under the guarantee provided for Swiss rules arbitration. It was not up to the court to decide whether the dispute was somehow or fell somehow within the scope of the sales agreement, because the award clearly established that it was a decision under the guarantee, and therefore decided to enforce the award. It also concluded that the losing party, the Chilean party, the parent company that I mentioned, had appeared before the Swiss arbitrators and even asserted jurisdictional objections. So this was not an issue of lack of due notice or lack of proper day in court, of the possibility of defending its rights before the arbitrators. And on that basis, the award was enforced. And I think this goes in line with a number of cases that have, in which the Supreme Court has declined to entertain any sort of argument that comes to the heart of the dispute or to the merits of the case, and has confined itself to analyze whether there is a ground under the New York Convention that would allow the court to refuse enforcement, and absent any ground, it basically dismissed the objections and order the execution or the enforcement of the award. About the role of Chile in arbitration, especially within the Latin American context, I would say, Tomas, that your point is right. We're seeing more and more cases that go beyond the limits or the jurisdiction of Chilean parties, cases in which there is not even the presence of one element related to Chile. disputes, for example, and a number of them between Ecuadorian state instrumentalities and foreign investors that call for arbitration seated in Santiago, Chile, disputes, and we've seen more and more between parties, Brazilian and Argentinian parties that have seated their arbitrations in Chile. And we're seeing that Chile is to some extent identified as a neutral forum, which has a proper arbitration law, a friendly system, an adjudicatory system that operates well, and also a legal community that is quite mature. And I think that provides some reassurance that the arbitration will be conducted properly in a forum that is equidistant from both parties. So we'll see what will happen. Of course, CAM-Santiago has played a big role there, as well as other international institutions such as ICC, where basically you see that they are fostering and promoting arbitration in Chile, and that creates greater awareness and greater interest from users and practitioners alike to be involved in arbitration.
Thank you very much, Cristian. Very interesting cases and decisions. Unfortunately, we are running out of time, so I would like to thank you again, Nicole and Cristian, the CCBC and Columbia International Arbitration Association for organizing the event. And I pass the ball to Gino for the next panel.
Thank you.
Thank you very much, Thomas. Good morning to all. We have heard really good presentations about the US point of view, as well as the cases of Mexico and Chile. Now we have reached the last panel, which addresses the situation of Peru. My name is Gino Rivas, LLM student at Columbia University, and I will be moderating this last panel. We have two great Peruvian lawyers as speakers today, Ana Maria Arrarte and Alfredo Bullard, both well-known arbitration practitioners in Latin America. Ana Maria Arrarte is partner and head of the dispute resolution practice at the Estudio Checopar member firm of Baker McKenzie International. She is also a member of the Court of Arbitration at the American Chamber of Commerce of Peru and is listed as arbitrator at the most prestigious arbitration institutions in Peru. Alfredo Bullard is partner at Bullard Falles Curra. He has also a Master of Law degrees from Yale and is Doctor Honoris Causa at Universidad Continental of Peru. He was president of the technical commission that drafted the new Peruvian Arbitration Act and is currently a member of the International Court of Arbitration, ICC of Paris. Well, I know that time is short, so I won't be speaking a lot more. Unless it's now time to hear the speakers. Ms. Arrarte, you can go ahead first. And I understand that you want to share some presentation. Just give me a second, please.
Yeah. Just if it's possible, no problem at all. Okay. Oh, I'm so sorry that it's not working for me. I can do it without the presentation, sorry.
Can you see my, I've shared my.
No, but it's not your problem. That's me. Please don't worry about the presentation. I can do it without it. Thank you, Gina.
Okay. Okay.
Okay. Thank you. I'm so sorry. Okay. First of all, thank Gino for your patience, and thank you everyone for being here. Thank you to the Center of Arbitration and Mediation of Chambers of Commerce, Brazil, Canada, and to the Columbia International Arbitration Association for the opportunity to share about arbitration in our countries, this time in Peru. So we must be honest and admit that our country, which we were very proud to be a model in arbitration, is going through a crisis that we hope to overcome soon. But let's see. I promise to be very, very brief. What was the outlook in Peru when adopting the arbitration law based in the UNCITRAL law? The promotion of investment that generates commercial and economic development in the country was a clear objective. Of course, having an efficient and a reliable dispute resolution mechanism was essential to provide the stability required for the development of the commercial exchange. Peru had a growing arbitration practice in commercial matters, investment, and public procurement. This issue becomes a sensitive issue. I think that probably Alfredo will talk a little more about this. In September 2008, the new arbitration law came into force based on the UNCITRAL model with essential equal rules for national and international arbitration, and with all the positive matters we already know. Indeed, Peru is a country with a particularity, which later become a two-edged knife, as we will see below. The arbitration law authorized the Peruvian state to submit contractual relations to arbitration. Even more, in the legislation that regulates contracts with the state, arbitration was determined as binding. Originally, this was a very good idea and of great importance. It allows important public works to be carried out, especially in infrastructure with relevant growth of investment in Peru, considered as a model country in terms of arbitration. Well, one of the main objectives of the arbitration law was to limit judicial intervention, to motivate a change of mindset. The judiciary is essential for the effectiveness of the arbitration, but its role is only of collaboration and guarantee for arbitration to work. The judiciary can only intervene when the law authorizes it, and under the terms provided for, through a subsequent control. There is a specific precedent called Maria Julia precedent. This precedent is from the Constitutional Court and determines the very exceptional cases in which an amparo can be initiated to challenge an award. But something is clear. Pro-arbitration tendency in the Peruvian courts is very clear. In matters of recognition of foreign awards and annulment of domestic awards. For example, I try to look out for statistics, and the statistics we have able to find out to 2020 determined that less than 19% of annulment claims are estimated. This is also exceptional, that when an arbitration award is annulled, it really is a news for all the lawyers in the practice. What is the state of arbitration in Peru nowadays? I first with the positive things. International arbitration standards are increasingly being applied and recognizing rules of local arbitration centers. For example, the rules of the International Bar Association in evidence and also conflict of interest are applicable to all local arbitration, scheduling of proceedings, emergency arbitration, scrutiny of the awards, etc. Another positive issue is our legislation allowed the appointment of foreign arbitrators to solve domestic cases, which provide high levels of experience. In commercial matters between private parties, arbitration continues to be the most used and consolidated mechanism for the resolution of conflicts. But there's always something but to say. Regarding to problems of corruption, we are talking about the Lavallato case and others, which affected the whole country, not only arbitration. The state has gone from being a subject that submitted to arbitration, and thus ensure individuals and investors equal justice, to one that does not respect or comply with the adverse decision. This is the double-edged knife to which we referred previously. Moreover, the state is creating rules to regulate the arbitration in which the participant rendering it totally useless and inefficient. But it's also important to say that our arbitration used to not apply those rules because they are clearly unconstitutional. This is generating, unfortunately, instability, little predictability, and with the loss of investment and relevant values. For now, what is apparently coming is a crisis situation that hopefully we can overcome. But now Alfredo will explain better this aspect, which I just talk about in a very brief introduction. So Alfredo, this is your time, and I will very enthusiastic to hear you.
Thank you, Ana Maria. Thank you, Gino, for the presentation. Thank you, everybody, for being here. I'm now in Spain, so for some people, maybe it's good afternoon. I think it's good afternoon for everybody right now. First, I will speak in the most spoken language in the world, which is bad spoken English, so sorry about that. I will try to be the most clear that I can. And mainly, I will say that I agree with almost everything that Ana Maria has just said. First of all, from time to time, I receive a call from a foreign friend that have never come to Peru, asking, I want to go to Peru for tourism, and I want to know, how is dengue doing there? And I said, dengue? Well, I don't know. I have never met somebody with dengue here in Peru, but I know that there is dengue. And dengue is very common. I talked with some people from other Latin American countries. When I told them this, they say, well, yes, I received similar calls from other people asking for dengue. And it's a strange question because, as I mentioned, dengue exists, but is not as common as many people think from other countries. And I think that in some way, I received the same kind of questions about arbitration sometimes. How is arbitration dengue doing? Which kind of infection is that? And which kind of disease it is, and which kind of risk this is? And I will say that usually, as in the case of dengue, most of the fears about what is going to happen with this arbitration dengue, which I'm going to explain, which I'm referring to, are mainly an exaggeration about the risks. In general, Peru have an amazing development of arbitration in the last 20 years. And really, I'm usually amazed of how trustable becomes the system during the time. But as Ana Maria mentioned, now we are facing a different problem, a new COVID that is coming, and that have some risks that are different to the usual risks that you face in other countries, or that people feel that you can find in other countries. Usually, the Latin American dengue is referred to intervention of courts in arbitration, and mainly constitutional courts, amparos. Many people, how is amparo doing in Peru in relation with arbitration? And if you look what is going on in Peru, really, courts have not been a real risk to arbitration. It's totally the contrary. Courts in Peru have been very friendly. They have changed a little in the last years, but in general, they are still friendly. And the precedents by the Constitutional Tribunal are even more friendly than the regular court decisions. And the precedents, one was mentioned by Ana Maria, the Maria Julia case is an amazing an amazing case saying how courts, and particular constitutional courts, have to respect what the arbitrators are doing. So the common menace, which are the courts, are not really the dengue that we are facing. We have different problems, and Ana Maria makes a very good introduction of the kind of problems that we can see are happening. Peru have an amazing development, as I mentioned, since the 90s. And that turns Peru, what I think is maybe the country with much more arbitration cases per capita in the world. It's amazing the number of cases that you have. If you divide the number of cases by the number, by the people, by the population, you will see an amazing number of cases of every kind. A lot of them cases with the government, with the state. Maybe most of the cases are with the state, which is something that didn't happen in any other country, or is not happening in any other country in the world. And that is because the Peru has a very friendly, basically the Peruvian state, the Peruvian government has a very friendly attitude toward arbitration. There are different explanations of why it happened. First, ordinary courts were pretty bad in enforcing contracts, and that affect not only private parties but also the state. So they look with sympathy to have arbitrators doing the work that usually you have doing this. And what is really amazing is that if you go to the procurement public law, the procurement governmental law, which regulates all the contracts that any entity of the state has to enter with any kind of private party, they have compulsory arbitration. They only are allowed. They have to have arbitration, and that means a huge number of cases that go to arbitration. Second, not only in this field, but in other fields, as in concession contracts, as in commercial contracts, the state was very friendly in developing this. The development of also was supported by the original uncitral model law in Peru, which came from the 1996. And then we changed that in 2008. The main change is we changed from a law that separates domestic and international, and we turned it a monist law. So now in Peru, a domestic arbitration is regulated by the same rules of the international as uncitral model law. There are only very few and specific differences, and that contributes a lot in the developing of arbitration, but also in developing standards. Now, if you go to an arbitration, a domestic arbitration in Peru, you will see that, specifically in the most modern sector of arbitration in Peru, it looks very similar to an international case in terms of the rules, in terms of the standards, and in terms of the arbitrators, because you have a lot of international arbitrators. Cristian is here, and he's arbitrating in Peru all the time. Francisco González de Cosillo, Eduardo Zuleta. The other day, we have a conference with Eduardo. No, it was before the pandemic, but we have a seminar in Peru, an in-person seminar, and Eduardo Zuleta was there. And the seminar was in the Lima Chamber of Commerce, which is one of the main arbitration centers in Peru. And in the break, we began to walk, and there were 2 hearings. From the 2 hearings, from the 6 arbitrators, 5 were foreign arbitrators, and men are very well known foreign arbitrators. And he told me it looks like the ICC. And the rules, arbitrators, the practice is very similar, and that is a very important development because in the last report of the IBA, Peru appears as one of the countries that uses more frequently the IBA rules, not only by arbitrators, but also by the courts. So that sounds very good news in terms of what is going on. But where is this new infection is coming? The new infection is coming, and I agree with Ana Maria, is coming of this enthusiastic pushing of arbitrators in state contracts. Because in that sector, some cases began to happen. Some are related with the incapacity of the state to deal with arbitration. They are not prepared. They are not keeping the contracts in the way they should keep it. When they are enforcing the contract, they are not taking care of what they are doing, and they create a lot of risk in the contract, which means that they have some bad outcomes in some cases. Corruption was the other thing. There are some cases, I will not say that the system is corrupt, but there is corruption in the system. There is some corruption in the system. And the lavajato is one of the examples. And as a consequence of that, the main problems that we are facing are the Congress trying to change the General Arbitration Act because of what is happening in some cases in the state or governmental arbitration cases. So they're trying to change because they think that the arbitration is not good for the state, but they're changing the General Act, which is referred to all arbitration, not only commercial, not only state parties arbitration, but also private parties arbitration. And that is created a continuous menace against that, the law, because they want to change the law in really, and I will be very direct, in many stupid ways, really stupid ways. They do not understand what is going on, and they're trying to change things as asking foreign arbitrators to, for example, have a university title register in Peru to that have not been approved, but they are discussing that. And the other menace came from criminal actions. They began to initiate many criminal actions, some with some basis, some without any basis, against very well-known arbitrators, which the case, one of the cases, the most known case is the case of Fernando Cantuarias, which he went to jail for 25 days. Because of a case which have no logic. He was there because they say that she received a corruption payment because there was a difference in the fees that were agreed by the parties to be paid, a very small difference. Totally crazy. And what is happening right now is that in that case of arbitrators, there is no arbitrators that want to give an award in favor of the private party. So the system is turning in an untrustable system for both parties. And that's the problem, is that people talk about arbitration. They are not talking about these specific cases. They are talking in general. Arbitration is bad. That is a mistake. That is not what is happening. But I will stop here. I think that I try to give a complementary vision, really, that I agree with almost everything. I think I agree with everything that Ana Maria has just said, and I am available for any question that you may have. Thank you very much.
Thank you very much to both of you. Sadly, we are running out of time, so I think that in order to just try to not lose more audience, I think that we should close this. First of all, I would just want to thank to everyone, but let me just state a small commentary. I fully agree with Professor Buller regarding these two main issues, or these two main topics in Peru that could be challenged and also convey some risks for arbitration in Peru. The public procurement arbitration regime could be a problem if it's not understood in the correct way. And also the criminal actions against arbitrators are something that it's something terrible, and it definitely gives a bad impression of our country, Peru. Well, with that said, we have finished today's panels. On behalf of the Colombia International Arbitration Association, and also on behalf of Cámara Brazil, Canada, I want to thank you, all of you, for being here, and especially to the speakers of this panel and of the previous panels too. And also don't forget, please, that this webinar will continue next Friday. So that would be it. Thanks to all. Thanks, Alfredo. Thanks, Ana Maria. It was nice to see you today.
Thank you. Thank you. Bye and take care.
Take care.
Bye.